My name is Ryan Ginn, and I'm a 2L at Tulane Law School. I'll be presenting on the Dutra Group v. Batterton, which is a 2019 Supreme Court ruling that held that punitive damages are not available to plaintiffs who bring a claim of unseaworthiness. So the plaintiff in this case, Christopher Batterton, was working on board a vessel when a pressurized buildup of air slammed a hatch cover open and crushed his hand. Batterton brought a number of claims against his employer, the Dutra Group, including one for unseaworthiness. In addition to seeking general damages, he also sought punitive damages and argued that the unseaworthiness violation was both willful and wanton. Dutra moved to strike or dismiss the punitive damages claim, but the district court denied that claim, and then the Ninth Circuit affirmed that denial. That denial by the Ninth Circuit created a circuit split between the Fifth and the Ninth Circuits, because the Fifth Circuit had previously held in 2014 that punitive damages were unavailable for unseaworthiness claims. The Supreme Court then granted cert in order to resolve the circuit split, and by a 6-3 vote, reversed the Ninth Circuit and held that punitive damages are unavailable to plaintiffs seeking punitive damages for unseaworthiness. So Justice Alito's majority opinion began by examining the history of general maritime law, and in particular, the way that the unseaworthiness claim has evolved over time. Federal maritime law arises out of two sources. There's general maritime law, which is developed by federal courts under the Admiralty Clause of the United States Constitution, and there's also statutory law that's created and enacted by Congress. And seamen benefit from a very prominent trilogy of remedies. There's two general maritime law claims, maintenance and cure and unseaworthiness, and that protect injured seamen. And the Jones Act passed by Congress in 1920 gives seamen a remedy for negligence. As the majority explained, the unseaworthiness remedy originally provided a cause of action for seamen who refused to board the ship or shippers who lost cargo because of the unseaworthy nature of the vessels that were involved back in the 19th century. And then in the late 1800s, courts began extending that unseaworthiness claim to personal injuries caused by an unseaworthy vessel. However, the biggest change came in the 1940s, around World War II, when unseaworthiness was transformed into a strict liability claim. And this transformation created a situation where unseaworthiness and the Jones Act were similar, although ultimately not identical. So in issuing its holding, the court primarily relied on Miles v. Apex Marine Corps, which was a 1990 case from the Supreme Court. And in that case, the court held that there's no recovery for loss of society in a general maritime action for the wrongful death of a Jones Act seaman. The opinion, however, included a few crucial sentences that downplayed the role of courts in protecting seamen and instead advised courts to use legislation as policy guidance and to seek uniformity between general maritime law and statutory law. It included, we no longer live in an era when seamen and their loved ones must look primarily to the court as a source of substantive legal protection from injury and death. Congress and the states have legislated extensively in these areas. In this era, an Admiralty court should look primarily to those legislative enactments for policy guidance. And so that reasoning began to be extrapolated by lower courts over the next 2 decades. So during the 1990s and early 2000s, lower courts used that analytical framework to deny punitive damages for general maritime claims, including maintenance and cure and unseaworthiness. However, in 2009, the Supreme Court allowed punitive damages for maintenance and cure in Atlantic Sounding v. Townsend. That decision limited the scope of Miles because the Supreme Court held that punitive damages were shown to have been available in maintenance and cure claims prior to the 1920 passage of the Jones Act. In passing the Jones Act, Congress created a statutory cause of action for negligence, but preserved existing common law remedies that were available under general maritime claims. Writing for the majority, in this case, Justice Alito constructed the opinion's framework around two primary conclusions. First, the court held that punitive damages were not historically awarded for unseaworthiness claims, especially prior to the Jones Act. Batterton relied primarily on two early cases from the late 19th and early 20th century in order to try and show that punitive damages had been awarded for unseaworthiness claims prior to the Jones Act. In both cases, the court held that the cases involved compensatory instead of exemplary damages, and so thus they distinguished those. And because they were not presented with any examples of punitive damages being awarded, the court concluded that those damages were not traditionally available in unseaworthiness claims prior to the Jones Act and thus were not preserved. And secondly, the court held that allowing punitive damages in unseaworthiness claims would be a novel remedy, and that action would not be necessary to maintain the uniformity principle that they espoused in Miles that would have created uniformity with Congress's laws. Because the Jones Act does not allow for punitive damages, and because no evidence was shown to put forth to show that damages had a historical basis for unseaworthiness, the court chose to maintain uniformity with Congress by blocking punitive damages for unseaworthiness claims. The dissent from Justice Ginsburg argued that the court's decision in Atlantic Sounding v. Townsend, rather than Miles, should be the controlling voice of the case. In Atlantic Sounding, the court held by a 5-4 vote that punitive damages were available for the general maritime claim of maintenance and cure because punitive damages had been available for such claims in a couple of cases prior to the Jones Act and thus had been preserved. Justice Ginsburg noted that both unseaworthiness and punitive damages predate the Jones Act, and therefore under Atlantic Sounding, there is no need for the remedies available to Batterton to uniformly match those available under the Jones Act. She also made a key distinction from the majority regarding the test to determine the history of punitive damages, writing, "True, there is no evidence that courts awarded punitive damages before the mid-20th century for unseaworthiness, but neither is there evidence that punitive damages were unavailable in unseaworthiness actions." In opposition to the majority, Justice Ginsburg argued that lack of proof that punitive damages were barred means they should be permitted. The court's holding in the noted case interpreted the framework of Miles too expansively and incorrectly limited Atlantic Sounding, which should have been the controlling case. In Atlantic Sounding, the court distilled its reasoning into 3 criteria that helped show seamen were able to seek punitive damages in claims for maintenance and cure. First, punitive damages have long been available at common law. Second, the common law tradition of punitive damages extends to general maritime claims. And third, there's no evidence that claims for maintenance and cure were excluded from this general admiralty rule. Using the dissent's interpretation, unseaworthiness passes the same analysis the court used to allow punitive damages for maintenance and cure. The first 2 criteria apply to any general maritime law claim, and as for the third, there is no evidence that unseaworthiness was explicitly excluded from the tradition of punitive damages. This point was best articulated by Judge Higginson's majority opinion for the Fifth Circuit panel in the original hearing for McBride prior to the en banc reversal. Judge Higginson noted that if a general maritime law cause of action and remedy were established before the passage of the Jones Act, and the Jones Act did not address that action or remedy, then that remedy remains available under that cause of action unless and until Congress intercedes. Like maintenance and cure, unseaworthiness is a general maritime law cause of action established prior to the Jones Act, and it is also not abrogated by the Jones Act. The dissent correctly reasoned that if there is no proof that punitive damages were barred, the holding in Atlantic Sounding mandates upholding the tradition of allowing punitive damages for general maritime law claims. Even if there were no cases where punitive damages were shown to actually have been awarded, there is nothing indicated that they were unavailable to plaintiffs prior to the passage of the Jones Act. The majority opinion asked for proof that punitive damages were awarded instead of simply available or not unavailable. However, the majority did not find any cases where punitive damages were awarded prior to the Jones Act. At the same time, it did not reference any cases that explicitly held that punitive damages could not be awarded. No legislation has shown that Congress intended to limit the remedies available for unseaworthiness. There's overlap between the Jones Act and unseaworthiness in its current form, but they are still not identical. And although unseaworthiness eventually became more similar to a Jones Act claim, that still doesn't show that Congress's intent in passing the Jones Act was to limit unseaworthiness remedies. Miles's command to look to legislation for remedies is not as applicable to this case as the majority viewed it. The court's holding in this case provided a significant victory for vessel owners who no longer faced the threat of punitive damages in claims for unseaworthiness. Seamen, once viewed as wards of the Admiralty, will now have to rely on Congress to pass legislation superseding the court's decision in order to have a chance to recover punitive damages for unseaworthiness. Thank you.